Dr. Muyomi, you have 1 hour and a half.
Chair, there is an emerging procedural issue we crave your leave to raise before we begin the cross-examination of the witness. And the issue is as follows.
Go ahead.
The governor has chosen, perfectly within her rights, that she will not give evidence. And whereas that's within her rights, and she can't be faulted for it, we find ourselves at a disadvantage. And the disadvantage is as follows. The governor has had ample time to challenge our case and our evidence, and specifically to challenge the evidence of the mover of the motion. Our problem is, even as she exercises her right not to take to the witness stand, she has filed before you several affidavits, one of them by herself, some of them 3 or 4 others, by persons who will not also be taking to the witness stand. By law, those affidavits are part of your record. By law, those affidavits are evidence. The whole essence of an affidavit is that it is sworn evidence in writing. To the extent that these people are not being called to testify, and specifically to be cross-examined, we run the distinct disadvantage that whereas the governor's side has had the ample opportunity to challenge all our witnesses by way of cross-examination, we denied an equal opportunity. Chair, you just said what is good for the goose is good for the gander. Now, our problem, Chair, is we can't force persons who are unwilling to testify to take the witness stand. But I also understand, whereas the decision the governor and the deponents of those affidavits have made is perfectly within their rights, the decision they took is not to give evidence in chief. We would want it to be clear from the record that we are making an application to cross-examine the governor and our witnesses on the deposition set out in those affidavits. Of course, Chair, they can still choose. They don't want to avail themselves for that cross-examination. If they choose, they have already chosen they don't want to give evidence in chief, perfectly within their rights. But if they also choose that they don't want to be cross-examined, and we are making the application under Rule 10 of your rules, that they be called so that we cross-examine them. They are not obliged to accede to that request, Chair, but it should be clear on the record that they are not amenable to be cross-examined, so that in our closing statements, then we'll crave your leave to address you on the implications. Because if that issue is not addressed, you remain with our evidence thoroughly challenged, which is okay, but the evidence taken for gospel truth without the opportunity on our part to show the gaps, to show the contradictions, hopefully some falsehoods, and in short, it will not be a fair trial. This is a trial. the Senate is sitting as a trial chamber. So let them confirm to you. We already have their confirmation that these persons will not testify. But let them also confirm to you for the record whether they also don't want to be cross-examined, so that we close that matter and then I can proceed with the business at hand.
Would you like to indicate precisely on what it is you would like to cross-examine the governor? Because he has given a lot of evidence. Are you telling the chair that you want to cross-examine her on her affidavit?
On her affidavit, Chair, and her formal response to the case, because she has filed before you a response to the motion. She has also filed before you an affidavit, which is evidence. We are entitled, of course, subject to what you decide, but by law, we are entitled to test that evidence, and every position she has taken in that response and in that affidavit, and it's not just our chair, there are several other people whose affidavits are also on your record, on our side. So to answer your question, Chair, we want to cross-examine her on everything set out in our response and specifically in our affidavit, together with those other affidavits of other witnesses. But she is the liberty, Chair. I must point out this, and I've said it ad nauseum. She has the liberty to tell you that she is not amenable, because at the end of the day, you cannot force anyone to testify. And even if you do, nothing useful can come from someone you're forcing to speak if they don't want to testify on their own case.
Yes, counsel for the governor, we shall hear you.
Thank you, Chair. We object to that application being made by my learned friend, Dr. Diankolu. One, for the simple reason that he admits that indeed there is no requirement in law that a governor or any accused person appearing before such a committee can be coerced or forced to testify. That is in the rules, and it would be against her right to fair hearing to compel her to utter even one word against her wish. The rules governing these proceedings, Honorable Chair, require the governor to elect means within which she will appear before this committee. She has done exactly that by indicating that she will be represented by counsel who are on record and have done exactly that. So we cannot offer the governor for cross-examination when she has not tendered any oral evidence before the committee. It will be a prejudice on her part, and we risk being accused of violating her rights to fair hearing. Even in normal criminal proceedings, Honorable Chair, any accused person, whether accused of murder, robbery, or any other offense, cannot be forced to testify. They have a right to even remain silent and have the court infer any inference of our silence. What needs to be done is for the prosecutor of this motion to table evidence. Ours is to challenge and punch holes on that evidence, and that's exactly what we have done. The governor's voice has been heard through our advocates. It would be a violation of our right to put her on this stand to be cross-examined against her wish when she has not offered herself for that exercise. Secondly, the affidavits that are on record were supplied to learned counsel. We did indicate, in compliance with your rules, how many witnesses we intend to rely on. That was not objected to. When we were introducing these affidavits, we did not at any time indicate that we would call these as witnesses, for the simple reason that the witness we've just brought here, we believe is a wholesome witness who is able to cover all the allegations that have been leveled against the governor, having personally witnessed and having personal knowledge of all the issues that are contained in the motion. Those affidavits merely corroborate what the witness has confirmed of events that he attended personally and has personal knowledge of. Those other witnesses would not really be so much useful to this committee because they are only meant to collaborate the evidence on record. But for the record, let me say this. Save for the governor, we are willing for the other witnesses to be summoned by this committee for cross-examination. We have nothing to hide. We are only trying to be considerate on the issues of time, but should this committee feel that there is need for these witnesses to be brought, then we can have them summoned subject to convenience of time. We have no objection to them being cross-examined. Unless I've left out anything, my learned friend can. Thank you. He says there is nothing I've left out. That is all, Honorable Chair.
I think then it is clear for purposes of the record, because for us we only want an...
Order. Relax, completely. You've made your application. Yes, you have invited your colleague to say something.
Honorable Chair, thank you.
Just hold. Proceed, sir.
Honorable Chair, thank you. There are only 3 issues I wanted to raise. I think the application by my learned friend has not been made at the most appropriate time because it's in the course of a testimony by our witness. He should have allowed us to complete this witness. He could examine this witness on any issue because we said this is a wholesome witness who would cover anything and everything. And he demonstrated which evidence this witness was not able to respond to upon cross-examination. At that juncture, he would have every ground even to demonstrate to this committee which issues he would like clarified, and he would like this committee to benefit from the evidence of any other witness. Then, other issue I would like to emphasize is that when we saw the issues of time and knowing what can happen, we decided to just get one witness. So the governor has planned her case from filing a response and affidavits, as well as fielding a witness who can attest to all those affidavits. The counsel for the county assembly indicates in exact precision that he would like to cross-examine even on the response filed by the governor. This response is not a testimony of the governor. It is a pleading or a document signed by the advocates for the governor. So even at that juncture, we'll have a complication, whether it's the advocate who proceeds to the start to be cross-examined. That's what we are saying. All matters in the response and all the affidavits. And an affidavit is a repository of oral evidence. The most the county assembly can do is to demonstrate the affidavits and the evidence in those affidavits has not been corroborated and it's not verifiable. And this witness cannot verify that. Or the other witnesses who have also testified by their affidavits cannot verify that affidavit. Once we get to that point, this committee would consider how else can it be able to verify the challenged or the impeached evidence by the governor. And Honorable Chairman, this motion was brought by the County Assembly. They have the duty to discharge the burden of proof beyond reasonable doubt before the evidential burden shifts to the County Assembly, to the governor. That's my contribution, Chair.
Thank you. I can see a red light there. Yes, Council, you appear for who?
I appear for the County Assembly. My name is Abdikadir Sheikh. Chairman, I would like to, of course, the committee and the chairman are aware.
Kadir, hold your horse. We now know you. Lead Counsel, is it your intention to invite Advocate Abdikadir to address us?
Chair, you can indulge him, but then again, at the risk of not taking too much time, I said all we needed in making this request was confirmation from the governor's side that they are not amenable to have the governor cross-examine. We are not even asking you to make a decision on the matter. because they have the right to choose. But that right has certain legal consequences, which we will address you on, and we don't want at that time to be accused of the ambush. So we have already had the position that they are not amenable to have the governor cross-examined on affidavit. And since that's all we wanted to go on record, the matter is resolved. So I can continue if you
Okay,
permit.
I've heard you.
But you can hear my friend Abdikadir.
I've heard you. Before I invite your colleague to come, are you really being fair to us? Are you attempting to play mind games? You make an application, we listen to it, and before we make a determination, you then make your own determination, and you say that to be reflected in the record. The least, counsel, be humble, counsel. You are not the only person in the least you can do, you put your case. Your colleagues have responded. Allow me to fall back to my team. They'll make an input. And if their determination agrees with what you want to be the determination, then be it. If it doesn't, then raise hell. Don't play mind games with us. Common sense.
Came out like I'm playing mind games with the Senate. The only reason I said the statement that seems to have caught you the wrong way is I acknowledge the governor has a certain legal right. She can choose not to take. So even as I make my application, I must be cognizant that she has that right. Yes.
Dr. Mudomi, this house has a long history of a tradition of discharging business. Here, the standard practice is that once you bring a matter to the attention of a committee or the entire parliament, that matter ceases being your matter. It becomes the property of the house. So your application has since become the property of this committee. You will bear with us. We make a deliberation and a decision will be made quickly. Yes, Ahmed?
Thank you, Mr. Chairman. In the rules when...
Sorry, Abdikadir.
Yes, thank you, Chairman. The rules said once the lawyers on each side were introduced, I thought we had the audience.
Abdikadir, I want you to introduce yourself and confirm that you are on the list of advocates on this matter. Once you do that, you'll address us. Please, introduce yourself in full.
My name is Abdikadir Sheikh, appearing with the doctor for the assembly members.
Yes, second part?
Second part?
Are you on the list of advocates?
I think I'm in the list, yes. And when we started the hearing, I was here the first day.
I'm not being harsh. It's just that if you are on the list of advocates, we've been going on from 24th up to now. We've not come out.
I could help you, Chair. Abdikadir joined our team after we had already. But if you check your answer of yesterday, I had already introduced him as part of my team. But he's not in the original list, so that we don't spend time calling.
You introduced him on the Hansard
Yes,
yesterday.
yes.
So, Secretariat, without wasting time, you will confirm on Hansard if Abdikadir is one of the councils. He will be allowed to address us. If subsequently we find that he is not one of you, everything that he will have said, we shall strike it out. Abdikadir?
Thank you, Chairman. Chairman, I wanted to comment on brief comments made by the Council for the Governor. Of course, the committee and the chairman is aware that this committee is not sitting as an appellate. An impeachment of a governor has got two processes. It starts with the assembly and it comes to the Senate to confirm. Since this is an investigative committee to confirm the allegations, the analogy given by my learned friend, like if it is a strict court, absolutely it's not. So I support the motion by my learned friend that it's only fair. Everybody who can help the committee to give information should do so. The comment I wanted to make about the analogy that they have the right not to say anything. It is different from a court setting. It is investigative. That's all I wanted to say, my chairman.
Your point is made. Colleagues, I now fall back to you. First light, I have seen a light from Sifuna.
Yeah, Chairman, as I understand the rules, if you look at Rule 10, it says the committee may, at the request of the county assembly or the governor, invite or summon any person to appear and give evidence before the committee. So that, in my understanding of that rule, all we need is a request from either the council, from the assembly, or from the governor, that they would want somebody summoned, and you and the committee would have the powers to summon that person. As to whether that person intends to participate in these proceedings or not, Mr. Chair, you will see that under Rule 11, there is the option of the county assembly or the governor choosing not to appear before this committee. And my learned colleague here has said that persons under the Constitution have the right to remain silent. My only question to counsel for the governor is, what is silence? I mean, silence does not mean speaking orally only. If you have filed affidavits before a committee such as this or a court of law, that is you speaking. That is not you maintaining silence. And it cannot be fair to the other side that you file affidavits upon which they do not get opportunity to cross-examine. The way to test the veracity of matters that have been set out in an affidavit is through cross-examination. So the question to council would be, what is the committee supposed to do with these affidavits that have been filed by the governor in the absence of opportunity for the assembly to be able to cross-examine that evidence before the committee? Lastly, Mr. Chair, I know my learned colleagues know a rule of evidence concerning documents called the best evidence rule, that in fact, Chair, as long as the higher or superior evidence is in possession of a party or may be reached by the party, no inferior proof will be allowed. My colleagues know what I am talking about. In the hierarchy of witnesses, I know you said that you selected these witnesses having considered the factor of time. I am just wondering, counsel, in the hierarchy of witnesses, who is the superior witness between your chief of staff and the governor? Who is actually facing those accusations? I would want some answers on those questions so that we can guide the committee on how we proceed. I thank you, Chair.
Chair.